a very good evening, everyone. Welcome to the Law Awareness Weeks at CDC 2022, Legal Considerations for Caregivers. So thank you so much for tuning in on this Tuesday night. So this webinar is a collaboration between the Law Society Pro Bono Services, LSPBS, the 5 Community Development Councils, the CDCs, the NUS Faculty of Law, the SUSS School of Law, SMU School of Law, and the Singapore Corporate Counsel Association Pro Bono Chapter, and is supported by the People's Association as well. So my name is Mei Zhen, and I am your host for this tonight's webinar on legal considerations for caregivers. So welcome, and I think more people are still streaming in. So let me just go through some housekeeping matters before we begin proper. So today, we will be using Pigeonhole Live for our Q&A session. You can submit your questions at any point during the webinar and also upvote on any questions that interest you. If you have a smartphone or a tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Next, key in our event passcode, which is law CDC09, as shown on the slide. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole Live on your device. If you are viewing this webinar on your desktop or your laptop, you should receive an invitation to launch Pigeonhole as well, which is our Q&A platform. Okay, so please also note that tonight's discussion is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. All right, so once again, a very good evening and warm welcome to the participants who are still joining in on tonight's webinar on legal considerations for caregivers. Let me just now introduce our panelists for tonight's webinar, which is Ms. Peggy Yee and Dr. Chen Shiling. So first, for Peggy, she is the director of PY Legal and has been in legal practice for more than 30 years. She also sits on various boards in the social service sector. So in this capacity, she is a passionate advocate for the vulnerable in our society. Peggy also serves as the vice chair of the Canossaville Children's and Community Services and the Disabled People's Association, amongst others. Peggy also sits on the Community Legal Clinic Committee and the Family Law Practice Committee of the Law Society. So in her many years of practice, Peggy has advised her clients in all family-related matters from the womb to the tomb. She advises different generations of the family too. So she strategizes for her clients so that they can understand and navigate the legal issues and challenges. Her areas of legal practice are, amongst others, probate and estate matters, and family and civil litigation. Next, for Dr. Chen, she is a physician with special interest in dementia and adults with intellectual disability, or ID for short. And she's deeply passionate about improving the lives of both populations. So she is the founder of registered charity, Happee Hearts Movement, which runs ID Health, which is a healthcare service that advocates and provides for the health needs of adults with ID, intellectual disability, and their caregivers as well. She also works with Khoo Teck Puat Hospital in supporting persons with dementia and their families. So Dr. Chen is currently a member of the Management Committee of Dementia Singapore, BSG, and chairs their Programs and Services Subcommittee. She is also a member of the Community-Based Support Services Advisory Committee in MIND, which is the Movement for the Intellectually Disabled of Singapore, and serves on their healthcare working group. So concurrently, she is also a member of the APSN, which is the Association for Persons with Special Needs, Programs and Services Committee. I'm not done yet. Dr. Chen is also a member of the AWWA Programs and Services Committee and sits on the board of Mulberry Oaks Limited, a center for adults with intellectual and developmental disabilities. Last but not least, she is also an appointed member of the Adult Protection Team at the Ministry of Social and Family Development and a member of the 4th Enabling Master Plan Steering Committee. So I have just read out the bio of both Peggy and Dr. Chen, which is very long and illustrious. And once again, welcome to all our participants tuning in. We have like almost 100 of us in here right now. So we will keep this webinar like conversational and lighthearted. I know you may be tuning in after work or after a long day of caregiving. So we want to just keep it light and because this topic is also one that can be quite heavy. So without further ado, let's go on. So now we're talking about legal considerations for caregivers, right? So among our audience, I wonder how many, maybe they're tuning in and you have been a caregiver for a long time, physically taking care of your loved ones during the day, or maybe you are one of the supporting caregivers, supporting your elderly parents, for example. So while we will keep this conversational, it will be useful for us to also go through some of the common legal instruments that you may have heard of, like what are wills, or lasting powers of attorney. Maybe you've heard these kind of terms before, and these could definitely help in planning for your loved ones. So yes, now I would turn over to Peggy to give us a quick explanation on what are the legal tools available. Yeah, Peggy, please.
Thank you, Mei Zhen, and hello, everyone. I must say that I myself personally, I'm also a caregiver. I have aged parents, 93 years old and 85 years old living with me. And in my practice, yes, I've also come across many caregivers who bring an elderly to my office. And as I was telling Mei Zhen and Shiling earlier, when they come to my office, what I usually do is, because when they are senior, when they're aged, you don't speak as fast. I've learned that when you speak very fast, they cannot catch it. So you have to moderate it. It's not just about speaking that tone and speaking slowly, but I also want to make sure that the client who's sitting in front of me knows what I'm saying. So for example, I like to say that I will always give my clients a primary 2 science test, or maybe a primary 2 English test. I'll joke with them that I'm giving them a test. In reality, when I do that, I myself can verify for myself whether they understand what I'm saying, whether or not they are attuned to what is happening around them, and whether they understand. So, okay, more on that later. As far as the legal tools are concerned, you see, I find also that the term, there's always this misconception that, oh, so-and-so is getting a bit on in age. Let's do planning. And in order to do planning, let's get a will done. But a will, just because one does a will, does not mean that everything is planned for and prepared for. One must realize that there are these 2 basic legal instruments. Everybody thinks that once you do a will, you would have planned for everything, but the reality is the will only takes effect upon death. So yes, when you are alive, you come to the lawyer's office, or you can draft out a will on your own, but I wouldn't recommend that unless you know all the legalities. But let's say you go to your lawyer's office and you draft out, you approve it, and you sign your will. You must bear in mind that a will, even though after you signed it, it's an enforceable document, but it's a legal valid document, but it is not enforceable until the testator dies. So what happens then if, after doing up the will, and then you keep it nicely in a drawer, and you've told your would-be executor, if anything happens to me, go to the last drawer on the bottom right, and that is where my will is kept. And you think, okay, I can now breathe easy because everything is planned for. Not so. What happens if, after doing up your will, you touch wood, you then get a stroke, or you become very ill and you're not able to manage your own affairs? That's why it is not complete if you just do a will. You need to also do up a lasting power of attorney. So a lasting power of attorney allows you to be able to, when you are alive. Oh, thank you for this slide, Mei Zhen. This will be useful. So a lasting power of attorney allows you to be able to, when you are alive, nominate attorneys donees, who are called donees, who can act in your capacity and who can do things for you. And the areas in which they can do things for you would be in these two areas in respect of your personal welfare. So they can decide, okay, where are you going to live? Would they put you in a hospital? Are you going to try this, but are you going to be put on this trial drug? Would they allow it, or a placebo? Okay, so personal matters like that. And then property and affairs would be your donee would be able to operate your bank account, would be able to sign documents for you. So these, bear in mind, are matters that are done for you when you are alive. Okay, so as opposed to a will only comes into operation and becomes effective upon your death. All right, I hope that makes it clear. So a lasting power of attorney, bear in mind, must also be done when a person has capacity. That's why I say, I will test my client first, whether or not they're in front of me to do a lasting power of attorney, an LPA, or a will. I will test them, because if the elderly client, and my client, mind you, is the person who is going to sign the LPA and or the will. My client is not the person who has brought the elderly to my office. In fact, as a matter of practice, I will always tell the person who brings the elderly to my office, I will tell that person, go down and have a coffee, and I'll call you when I'm ready, because I don't want, I don't want that person around. I don't want the elderly to feel any bit of pressure at all. And sometimes after that person leaves, I do have my client, i.e. the elderly, looking behind to say, oh, is so and so really gone? And then you find them talking. So, but that's what I do. Okay, primary 2 test and making sure that the person is gone. All right. So that's the basic difference between a will and an LPA.
Yeah, and I guess with life expectancy getting longer and longer, we may think that, like what you said, we get a will done and we think that's it, right? But actually, in between life and the last few years of our end of our life, it could be a very long time, like 20 years, from 60 to 80. Yeah, and a lot of things could happen during then as well. So that's where the importance of this lasting power of attorney comes in, right? LPA. Right.
Perhaps, Mei Zhen, I may move. I will also, whilst we are talking about legal tools, let me just say a few sentences, because as you know, in order to do up both of these legal instruments, you must have mental capacity. Let me just say a few sentences on what happens. So let's say the elderly client who's in front of me does not pass my primary 2 test. Okay, but I'm only a lawyer. I'm not a doctor. The doctor is the pretty doctor who will speak to me. So, but let's say my client does not pass the test, right? What do? I will then inform the person who has brought the elderly person to my office that, look, I'm not able to take instructions to draw a will or to prepare the LPA, the lasting power of attorney, for this particular person. And then I will say, you need to bring this person to a doctor in order to ascertain whether this person has mental capacity. Because if the person has no mental capacity but is alive, right, and yet needs some decisions to be made or some actions to be carried out, like, for example, they're in the middle of a sale and purchase transaction and she needs documents to be signed, or they want to purchase a property, right? So and this person no longer has the capacity and therefore is not able to carry out these functions, then what the caregiver or the person looking after will have to do is to apply to court under the Mental Capacity Act for a court order under the Mental Capacity Act, and for that person to be appointed as a deputy. So the difference in terminology is, under the LPA, the caregiver is known as a donee. Under the MCA, the Mental Capacity Act, the caregiver is known as a deputy. And when an application is made to court under the Mental Capacity Act, then the eventual court order that comes about will frame in very strict terms and in very strict and clear terms the ambit and the extent of the deputy's powers or what the deputy can do, because there are many things that the deputy cannot do. Like for example, the deputy cannot make a will for the aged person, but I'll go more on that later. So will, LPA, and if there's no capacity, then an application under the Mental Capacity Act.
Yeah, so Peggy, I was very fascinated by your primary 2 test thingy. So if you pass the primary 2 test, can write will. Cannot pass the primary 2 test, that means send to a doctor. So maybe at this stage, right? So that's where we have we're very happy to have Dr. Chen, who is a doctor on our panel. So perhaps Dr. Chen, I think you see many patients who are perhaps a bit sometimes on or sometimes off, and the lawyers are scared. They don't dare to take instructions from these kind of patients or elderly. They send them to you. How would you, can you tell us more about what is mental capacity? Is it really I can pass the primary 2 test means I have mental capacity, or what is that actually? Yeah.
I think
Or how do you assess it? Yeah.
Yeah, I think the first thing is to ask ourselves, what primary 2s are we looking at? If we're looking at the primary 2s in Singapore, then the level is very high, Yeah.
Oh, primary 2.
Because yeah. So are we looking at, so I think the whole idea is that I think mental capacity is actually decision-making ability. Yeah, essentially that's what it is in layman terms, or in very simple terms. It's the ability to make decisions for ourselves, and that is what mental capacity is all about. And I think, thanks very much for the slides, and also thanks very much, Peggy, for sharing. I think it's very real. I mean, most of the patients that I see either have dementia or they have intellectual disability, right? So there is always the question of capacity, like how much decision how much capacity do they have? What kind of decisions can they make for themselves? So therein lies something that is really, really important about decision-making ability and decision-making capacity, is that it is very, very important to remember it is decision-specific. So that means even a primary 2 child, for example, right, using the primary 2 test, as just the benchmark, a primary 2 child, for example, may be able to make decisions, right, about what he or she wants to eat, for example. And as a parent, you would ask your primary 2 8-year-old, like, oh, do you want to eat chicken rice, or you want to eat Hokkien mee today, for example? And you may give them the autonomy to make the choice because they understand how to make that choice. But will you ask your 8-year-old, oh, should we sell this house and then buy this other house? Of course, cannot, right? Yeah, because they don't have that capacity to make that kind of decisions. So I think that's the first thing that I want to say about capacity and decision-making ability, which also brings me to the question that Mei Zhen, you actually asked about what happens when patients come to me, right? And they tell me that, oh, I went to see a lawyer and the lawyer asked me to do this, or I went to see somebody and they asked me to get a memo from you about my ability to make decisions. Actually, the first question I ask them is, what decision is it that you are actually trying to make? And what is it that this person actually requires in that sense from you? Because that is really important. Because the ability to make a will versus the ability to make a lasting power of attorney versus the ability to decide who you want to live with versus the ability to decide what you want to wear today, for example, is really quite different. Yeah.
Yes, there's a whole spectrum of it. So, right, so that's mental capacity. So, at this juncture, I do see some questions coming in. So one is this. So an elderly needs to draw up a will plus LPA in summary. Is it? Maybe I could let Peggy answer this.
My very straightforward answer is yes. That would be the most prudent thing to do. But of course, let's get this clear. There is nothing statutory about it. All right. That means there's no law that says that you must have a will and you must have an LPA. But my advice is it is the most prudent thing to do, because it really enables you to plan for what will happen if you're incapacitated whilst you're alive, and to plan for what happens after your death.
Okay, good. So we also have another query, since we're talking about LPAs, right? So this query goes, hi, when do you think a suitable age to do LPA for women? So it's specific to women, and I guess we're an all-women panel, we could take this question. So is it a time off, or you need renewal based on what circumstances? So I guess the query is, do you need to refresh or update your LPA? Yeah, or is it just a one-time off kind of thing? Yeah.
maybe I'll start first by the first part of the question. I
When is
don't
the
think
suitable age?
LPAs are gender specific.
Yeah, of course they're not. I'm just kidding about it.
Yeah.
Please.
Yeah, that's right. And there is no specific age, so long as you're an adult, and because one never knows when one can become incapacitated. You
Right.
know, it can strike at any age. So I think whenever you feel that you want to make preparations and make the right arrangements, you can do that. And there's no expiry date. So once you get it done, you know, unless you change it, it stays there. Because an LPA, once you've drawn it up and once it has been issued by and witnessed by the certificate issuer, it gets registered at the office of the public guardian, and it stays there as a record.
So in short, there's no need to like update or refresh that LPA. Okay, so we hope this answers your question. So maybe we can go into the next slide about deputyship versus LPA. So I think Peggy, actually just now you were already going into this comparison on if there is no more capacity, then the appropriate instrument to use would be this deputyship to apply to court, right, for a deputyship. Yeah, so
maybe at this stage, since you've got this beautiful slide done up, I'll just add on a bit more. I also want to make it clear that when you make an application for deputyship under the MCA to court, the court order that comes about requires a lot from the deputy as far as accountability is concerned. So you have to account, for example, to the Office of the Public Guardian, how you manage the patient's funds and what you have done, what your care plan has been, and how much you've adhered to it. If you've not adhered to it, why? You know, as opposed to a lasting power of attorney, because you bear in mind that when it is a deputy who has obtained an order of court, that patient no longer has mental capacity, and therefore rightfully so, the court and the Office of the Public Guardian are very concerned to ensure that everything is done right. As opposed to when you are alive and you have not lacked mental capacity, i.e. you still have capacity, then at that stage you have already drawn up, you do up your LPA and you make provisions. Okay, if I lose that mental capacity, I will then have my daughter and my son-in-law to act on my behalf, to do things on my behalf. They can then decide on my personal welfare matters, and then they can decide what I should do with my property. You know, do I sell it or not? So, but these decisions, you bear in mind, are made when the donor, that's the person who's drawing up, who's signing the LPA, when the donor has mental capacity. So it gives that donor the flexibility to do what the donor wants, and therefore the court does not get involved. Okay, so that's the distinction between deputyship and LPA, accountability and flexibility.
Right. Okay. So if just to summarize, you are saying that LPA, the court does not get involved. You just make that decision on your own. And when you have mental capacity, you're able to decide for yourself. And I think just a bit on the process of how you get this done, right? You still have to visit a certificate issuer, right? Which is a doctor or a lawyer that can help you get this done. But you don't have to go to court. It's not that complicated. Right. Okay. So now that we have a quick primer on what are wills, LPAs, and deputyship, we are going to go into some common scenarios that you may, we hope are of interest to the participants who have tuned in tonight. So we are going to the first scenario. Let's cover this one about caring for the elderly. And along the way, if you do have other scenarios that you're thinking of that are not mentioned here, please do put it in the chat. We will make time to go through it. Okay, right. So now, for the quite a common case would be caring for elderly. Let me just read it out. It says Max, 50 years old. He looks after his mother, who is 75 years old, in their one-bedroom HDB home. So Mrs. Tan, the mother, has been diagnosed with dementia back in 2017 when she was 70 years old. So Max, who was working overseas returned to Singapore to care for his mother, and he has no other siblings to help share the burden of caring for his mother. So for this scenario, maybe Dr. Chen or Peggy, which of you would like to chime in first on what you would say to that?
Peggy, maybe you go first, because maybe they
Sure.
will come to a lawyer first, right? Yeah, and then I can add on after that. Yeah.
So let's say Max brings Madam Tan to my office, and let me also say my primary 2 test is just my personal, it's my personal line about it. It's not provided anywhere, okay? But I say that tongue in cheek because essentially I'm saying I want to, for myself, test whether or not they know what is happening. So, but your scenario sets out that Mrs. Tan has been diagnosed with dementia. So if Max comes and Max tells me, Peggy, my mother has dementia, but since I'm back here and I have 14 days here, I want to do as many things as I can. What can I do? So I will tell him, well, if you're looking to do up a will and an LPA for your mother, I'm going to tell you, sorry, I can't do that because I would have spoken to Mrs. Tan, and if Mrs. Tan says, if I ask Mrs. Tan, do you know where you're staying? Or I ask her in dialect or in Mandarin, 你知道你住在哪里吗？你把地址告诉我. What is your NRIC number? And she stares at me and she doesn't know what is happening. That is, so certainly I will not be able to take any instructions at all. Then Max will then ask me, then what's going to happen to this particular flat, that my mother is living in? And well, if Mrs. Tan passes away without doing an LPA, if she passes away without a will, then the flat would be devised under the laws of intestacy, and since he is the only son, I assume there is no husband. Okay, I assume there's no husband. Then it will all go to Max if Max is the only child, because when you see he has no other siblings to help. Well, speaking as a lawyer, I nitpick. Do you mean that there are siblings around, but the siblings are not there to help? There's a difference, right? Because if there are siblings other than Max and Mrs. Tan dies, then her flat would be divided equally amongst her living children. Okay, but if Max is the only one, then it goes to him. Then perhaps just a bit further, if, for example, let's say I just tweak your scenario a bit. If Mrs. Tan owns the flat, holds the flat jointly with Max, let's say, okay, and they hold it as joint tenants, then actually upon Mrs. Tan's death, because they hold it as joint tenants, Max would get the flat transmitted to himself in whole, without even having to go to a lawyer and get a grant drawn up. Because if it's a HDB flat, just a notice of transfer will suffice. So that will help you to save money, So if you don't have legal costs, so be it.
Well, it's provided the property is already in Max and the mom's name, joint name.
If it is held jointly, correct.
Okay. Right. So just thinking one step further, if Max wants to do this step, but now the property is currently in Mrs. Tan's sole name, but he can't just go and ask Mrs. Tan just appoint him as a joint. Even to do that would be a change.
If Mrs. Tan has capacity, then Mrs. Tan can actually transfer part of the flat to him, and then they can henceforth hold it as joint tenants. But if she no longer has any mental capacity, then I would tell Max, well, you have to bring your mom to Shiling and get me certification that she is able, that she has the sufficient capacity to do what you think or what she will want to instruct me to do.
Yeah, so Shiling, you have shared a little bit about the patients that you see and assessing mental capacity. So now maybe turning to this specific scenario, what else would you like to share about it?
Yeah, okay. I think this is a very common scenario, right? An elderly person with dementia, diagnosed with dementia, and then they have children or a child who's trying to plan for them, or trying to figure out how to care for them. I think the first thing first is the crux of this entire thing is really about the capacity of this particular person who is Mrs. Tan. And I think the first thing that I want to say to everyone here who's listening to this webinar is that having dementia, again, like we already said earlier, right, doesn't mean no capacity. Okay, that's why, like Peggy said, she will still do her own assessment, right, of the client that comes to her. I mean, for us, we call them patients. For lawyers, call them clients. So she will still do her own assessment, simple assessment of the client first. Yeah, if the client clearly has capacity, then actually there is no reason not to be able to do some of these things like will or lasting power of attorney, if they can fully understand and comprehend and appreciate what it is that they're actually trying to do here. Yeah. So of course there are steps in which we assess capacity, but I think first of all the key issue here is dementia doesn't equal no capacity. I think that's very, very important. Yeah. The stage of dementia, of course, makes a difference. If this is very early in dementia, of course, the level of capacity will be higher. If this is very severe dementia, that means it has gone through the mild, moderate, and now is in the very advanced stage of dementia, then clearly capacity is likely to be a bigger problem in this situation. Yeah, in which they will not even potentially have the capacity to even make basic decisions about their own self-care, right? Yeah, so I think that's the first and foremost most important thing. So whatever it is that Max wants to plan for his mom, I think we need to know what it is that he wants to plan. Is it a will? Is it a lasting power of attorney? What is it exactly? Is it that he wants to find out what mom wishes for herself if she reaches a point where she needs a full-time caregiver, whatever it is, what is it that he wants to understand or what is it that he wants to plan for mom? So I think that's the first thing that is very, very important. I think the second thing that also comes up in this particular scenario is also relates to what Peggy said earlier about the difference between a deputyship and a lasting power of attorney, and why it is that it is important to try and get a lasting power of attorney done whilst you have capacity. Because if you think about it, a person who doesn't have dementia or a person who has early dementia can do a lasting power of attorney, right? Yeah, but if you reach an advanced stage of dementia, okay, and now you don't have the capacity to understand what is a lasting power of attorney and you want to do it, you can't do it anymore now, because when the doctor assesses you, you don't understand what is a lasting power of attorney and you can't do it now. So if you really need to plan, then you will have to go down the route of applying for a court-appointed deputy, which is far more complicated, far more cumbersome, and far more difficult, and more expensive as well for the family in that sense. So I think that's why it's so important that if you have capacity to try and plan as early as you can for yourself. But at this point, I also want to say this really, really important thing, which is that, so I have many patients who come to me, in a state in which they haven't done an LPA, they haven't done a will, but they no longer have capacity to do either. Yeah, which means that then the family will say, okay, then what do we do now? Okay, the next question I'll always ask them is, what do you need to plan for? Actually, tell me what you need to plan for. Tell me what is in your mother's name, for example. Is the flat in her name? Does she have a bank account in her name? And I would then after finding out what is actually in the person's name, okay, the next thing I will ask is, what do you need to do with this thing? Do you need to sell the flat urgently? Do you need to tap on the money in the bank account urgently? If the family comes back to me, right, and these are very common scenarios in our local setting, one thing they will tell me is, actually, doctor, there is nothing in her name. Nothing. A lot of our ama, akong got nothing in their names on, everything already transferred or else joint account, very common. A lot of my patients have this. Yeah.
Joint bank account in the son and the parents' name.
Exactly, so very common.
The son could still use it, right? Operate the bank account.
Exactly. Yeah. Or so I would tell them, okay, if that's the case and you have no intention to, and there is nothing you need to really shift around, let's say there's nothing in the ama's name, right? Yeah. Then in a way, a lasting power of attorney is not urgent. Yeah. Because we can talk about her personal welfare. We can discuss her end of life plans. We can talk about all these things. We don't need to legalize it with a document in that sense. So I think that's the first thing I would say to them, if that is the situation. Second situation is there is something in the person's name. Also happens quite commonly when I meet my patients. Then they will say, yeah, there's a bank account in her name, or half the flat is in her name, or there is this, or there is that. Okay. Then same thing, I will ask them, okay, what do you want to do with this? Are you intending to sell this flat at this moment or do something with it, rent it out, do whatever it is while your mom is still alive? Yeah. Or are you intending to take out the money from the bank account? I can tell you a lot of times, right, the families will come to me and say, no lah, doctor, I think actually we already discussed already lah. The bank account only got like maybe $5,000. It's okay lah, we just leave it there. We don't really need the money. Then the house, no lah, we want our mother to stay there until she passes on. Yeah, things like that. So if that's the case, again, if there's no urgency to do anything, right? Then I would tell them in that sense, again, same thing, personal welfare, health-related issues we can discuss. You don't need to go and rush to get a deputyship done. Conversely, if let's say they tell me this is very serious, we have like $1 million in my mother's name, we need to deal with this, if not we cannot care for her or we cannot whatever it is, right? Then I would say, okay, if your mother cannot do a lasting power of attorney because she doesn't have the capacity, then let's proceed to get a deputyship done, because you need to unlock these assets in that sense. So again, I would say actually it's very, very customized. Every single family is different. So for all my patients, right, in order to help them to decide as well, I would of course assess the capacity, I will assess their needs, and then I will weigh the pros and cons and the benefits and the risks with them. Yeah.
Yeah. So I also have heard of friends who only, needed their dad got into a traffic accident, had a stroke, and then there was an urgency to do the deputyship only because they need to get insurance proceeds, for example. That's also another common reason, right? So right, okay. So
Mei Zhen, let me just add on to what Shiling said about there not being a necessity to rush out to get these instruments done. And that's a very good point, because likewise with a will, all right. Let's say Madam Tan, okay, let's use Mrs. Tan again, and let's say Mrs. Tan this time has no dementia. Okay, she's 75 years old. She comes into my office with her walking stick, and then I said Max, because my client, remember I said earlier, it's not Max who has brought her to my office, but my client is Mrs. Tan. And then Mrs. Tan says, Peggy, I'm getting old already lah. I want to settle. I want to unbuy everything. I want to unbuy everything and plan nicely. I have my HDB flat. I also have bank account. My children put money inside. So I want to plan. I want to give it to different people. I want to make sure that it all goes to my children, so that the government won't take it away. So this is a misconception, of course, because I have had quite a few elderly clients who say, oh, I heard at the coffee shop that if I don't do up a will, if I don't do any papers, the government will take away all my money. That is not true. Okay, that is not true. So if Mrs. Tan, who is 75 years old, with a walking stick, comes to me, I talk to her and I say, so what do you want to do, Mrs. Tan? And she says, oh, I want to make sure that I have the right legal documents and the right legal papers done. They call it papers, so that when I die, everything that I have will go to my 4 children in equal share. After all, my husband has already passed away. I have 4 children. I don't want them to fight. So I just want them to have everything that I have in equal shares. Then I will tell her, actually, Mrs. Tan, you don't even need to draw up a will, because upon her death, her assets, if she has 4 children, no spouse, her assets will go equally in 4 parts to each of her 4 children anyway.
Assets meaning covering the HDB as well, her bank account.
Let's say the HDB is in her own, her flat is or her property is in her sole name, all right? Not under joint tenancy, but in her sole name. Then her assets, meaning her property, her bank accounts, and let's say she has some shares, and then she has she has jewelry, and everything will be bundled together, and it will be divided between her 4 surviving children in equal shares. All right. Now, if, however, Mrs. Tan then says, out of my 4 children, the first one I weighed in already because left the family. The second one I don't want to provide for because I've already given him his university education and a large part of money already. I want to, whatever I have will go to number 3 and number 4 in equal shares. Then I will tell Mrs. Tan, correct, you will have to do a will. Because if you don't, under the laws of intestacy, it goes to all 4 surviving children. But because what she has planned for, like Shiling was saying, ask first, what is it that you want to do? And she has already explained, number 1, this has happened. With number 2, this has happened. So I only want to give to number 3 and 4. Then to draft up. Then I will draw up a will for her with her intentions like that.
Right. And I think the earlier scenario that you answered, right, also helps to answer one of the questions posed, which is assuming there are siblings and there is no will and the parents stay with the son, and will the HDB still be distributed equally among the siblings, or must the flat be sold, or will the flat just go to the son because the son is staying there, right? And assuming the flat is sold in the parent's name. So I guess you have answered it already, right? So if there's no will and there are multiple siblings, be it 2, 3, or 4, then
Children,
upon the death,
it will be children. It will be her
children.
children, not Mrs. Tan's siblings. It will be, when you say siblings, I take it that you mean Max's siblings.
Yes. Right.
Okay.
So yes, I think that answers this question as well. Okay. Let me just take a quick look at the Q&A. There are quite a number of questions. Okay, so maybe I can also address this one now. It says, if an elderly has mental alertness only at certain time of the day, how effective is the will or LPA when she is not alert at other times? Yeah, maybe Shiling, do you want to speak into that?
Maybe I can answer this one. Okay, so for example, if we say that a person has mental alertness only at specific times of the day, right? That means most likely this person has an underlying impairment, okay, that is either stroke related, dementia related, or drug related, medication related, okay, that is actually affecting the person's cognition at specific times of the day, correct? Okay, so just now I said this thing, right, about how when we assess a person's mental capacity, it is decision specific, okay? Now is a very good time to add on another point. It is time specific as well. Yeah, time specific as well, okay? That means that if, let's say, I have a person with dementia, okay, and specific types of dementia, let's say, because not all dementias are like that. So that's why it's important to understand the clinical scenario. Yeah. So if I have a person with dementia, specific types of dementia that has fluctuating alertness, let's say, yeah, for whatever reason, for various reasons, then number one, when we want to assess the person's mental capacity for whatever it is that we want to assess, let's say it's for LPA, then we need to make sure that we assess it at a time when the person is most alert, because that is the fairest to the person in that sense. So just now, Peggy also said something that was very important, which I wanted to highlight as well, was that she said that when she talks to the elderly person, she will use different languages, right? Sometimes, or dialects, or whatever it is. Exactly. It is very, very important that when we want to, because if you think about it, when you assess a person's capacity, it's all about communication. It's about talking to the person, explaining things to that person, and then for that person to be able to understand what you're saying, and then weigh the pros and cons of this decision, and then communicate it back to you in a way that makes sense to the person. Okay? And of course, to you as you listen to the reasoning behind the decision. Yeah. So I think if that's the case, then communication is key, right? So therefore, you have to make sure that when you're talking to this person and explaining things, you use the correct language, the one that they're most familiar with. You make sure that if they have a hearing impairment, you ensure that they have a hearing aid that's on so that they can hear clearly what you are saying. And then, of course, you assess them at a time when they're most alert. Yeah. So because it is time specific, right? So that means if you assess at that point in time and the person is able to pass your mental capacity assessment test, and you are confident that this person has the mental capacity to make this particular decision, let's say this is an LPA that you're talking about, then this person has capacity to do that LPA at that point in time. Okay. And it doesn't then matter, whether, because if let's say the next time somebody asks you about the capacity, let's say tomorrow, and the person is in a very sleepy state, then the answer that you should give to the next person is, you should wait for my father or my mother to be more alert before you assess the capacity again. Yeah, that's the answer that should be given in that sense. So that's what I would say about capacity. And that's why it's so important to understand the clinical scenario before making a decision. Another related question, right, that comes with this is, what if the person is very forgetful? Yeah. All right. So, some of our patients with dementia, right, they are extremely forgetful, Tell them now, right, then 5 minutes later, they will forget the answer, or they forget the question. They forget that you even asked me, you mean you asked me this question just now? Yeah, and it's almost like they don't remember what you actually asked them earlier on. Does that mean that the person has no capacity? Again, right, the answer is no. If they can retain the information long enough for them to make the decision, okay, they can, and we assess and say that they can retain, they can judge, and they can communicate back their decision to you, right? and we assess that they have capacity for that particular decision, this is considered capacity. That means if 10 minutes later, I talk to the person again and it's as if it's completely fresh, right? It doesn't mean the person has no capacity. Because the likelihood is when I communicate to the person in the same way, it is very likely that the person will come back with the same answers. And in fact, that's usually what I'll do. I will reassess again. And if they are very consistent in their answers, okay, then it's very clear to me that they have capacity. But I would also caution everybody here that if your family member, because many of them are caregivers, right, sitting in this webinar. So if your family members are people who already fall into this category, that means they have fluctuating consciousness, they may be more alert at certain times or whatever it is, right? I would say that you should bring them to their primary doctor, be it a psychiatrist or a geriatrician or whoever it is that is their primary doctor, right, to do that capacity assessment first before you do any of these things. Because it is very likely that you bring this person to any lawyer, the lawyer will say, no, we're not sure whether we can do this. You bring this to, let's say, a GP that is registered as a certificate issuer. The certificate is not fair to the GP, I think, because they wouldn't know for sure, right? Yeah. And it's also not fair to your mother or your father, because what if it's at a time when they're not so good and the GP says, I don't think they have capacity. But actually maybe they have. So you should go back to the primary doctor, the one who knows your father, your mother, or your family member the best, and then discuss this with them. Yeah.
So even if they forget their answers, but you could ask again when they are more like clearer state of mind, right? Yes, Peggy.
Yeah.
Just to add on, you see, I have had clients whom I've sent away because I asked them questions and they seem to be very blur. But the next day or a couple of days later, the same client comes and is communicating with me fine, you know, like very, very cogent answers, very lucid. How old are you? Where are you staying? And they can tell me their address without looking at say a prepared piece of paper, you know, and what are you here for, Mrs. Tan? They can tell me very cogently. So switched on is what I call it. So now that Shiling has explained it, you know, it all makes sense. But as a lawyer, if the caregiver and my elderly client who can have on and off days, if they come with a medical letter or with medical certification from the doctor that this patient, from my assessment, this patient has the capacity to execute a will and or to sign an LPA, well then, you know, then everything is good and I can get it all done. Okay, so that for me as a lawyer would be, you know, very assuring. And this way, you know, for the caregivers, you know, please bear in mind, get that done. That's the surest way of settling the matters.
So if they show up with already a doctor's report saying that they have mental capacity, certifying that they have mental capacity to do it. Okay, so I guess on this note, there is a question related. It says, if a will is made with two witnesses, a lawyer and a psychiatrist, to ensure the mental capacity of the will maker, can the will be challenged in future? So we're not sure whether, you know, is there a doctor's certificate, you know, certifying mental capacity, but it was witnessed by a lawyer and a psychiatrist.
From a legal perspective, and I will leave the medical perspective to Shiling later, but from a legal perspective, every will can be challenged. But the question becomes, is the challenge a valid one? Because just like you cannot stop a dog from barking, you know, if you have anybody who wants to challenge a will, you can, right? But if you have it, so just because you have a doctor, in this case, a psychiatrist, and a lawyer who are the witnesses to the will, then upon it being challenged, these two professionals who have witnessed the testator executing the will would be able to give very credible evidence in court upon that challenge being heard that the will was drawn up properly and that the testator had the requisite mental capacity to execute that will, and therefore the challenge will most likely not succeed. Okay, so I'm choosing my answer carefully because, the question is based very widely. Huh? All right, so I hope that answers the question from a legal point.
Yeah, maybe I'll just add on a little bit to what Peggy says. I completely agree with Peggy and what she says, and that it definitely can be challenged if people want to challenge it, right? Yeah, it's like I can make a decision. Any of us can make a decision, and somebody can want to challenge it, in that sense. So they may not be able to challenge. They can challenge it based on many different things, lah. Yeah, if you think about, I just give you something concrete so that maybe you have something to hold on to. They could challenge it based on the fact that because here, right, is focusing when you put this scenario, the particular person who asked this question, you're trying to say that the capacity is settled, right? Yeah. So got a psychiatrist, got a lawyer, and then got 2 witnesses, so capacity is settled, right? Yeah. But there are many other things that people can challenge based on, they can challenge based on undue influence, for example. There is a common challenge, right? We read about in the newspaper all the time, right? People say, this one was forced into this lah, pressured into this lah, things like that. So that is a different thing that they would try to, that potentially could come up as well. And that's potentially why people may challenge certain things. But exactly like what Peggy says, if things were done appropriately and properly in that sense, and if you have witnesses, then they would, and they keep clear and good documentation, right? Then they would be able to draw on their own documentation of the event, which means you have very strong witnesses, to stand by what actually happened on the actual day lah. Yeah, that's what I would say as well. Yeah, but from the doctor's perspective, usually we would look at the capacity part lah. Do they have capacity or do they not have capacity in that sense? Yeah.
Okay. I hope that answers your question. And Peggy, you want to say something, but I was thinking we can move on to the second scenario.
Right.
Yeah, okay. So let's move on to the second scenario, which focuses on, just now we will focus on caring for an elderly. Next, we would be talking about caring for an ID adult. That means an adult with intellectual disability. So I think as we go through this second scenario, we will also answer some of the queries that have come in. So this scenario is Belle, who is 60 years old, has a daughter, Samantha, who is 30 years old, who is intellectually disabled. So Belle is presently physically and mentally sound, the mom, right? Her biggest worry is actually her daughter, if one day the mom becomes ill or is no longer around. So her husband passed away 10 years ago, but Belle has finally managed to pay off her late husband's debts 2 years ago. And her extended family shunned her and refused to offer help when approached. Yeah, so actually this scenario, I understand that, Dr. Chen, when we're preparing, you have a passion for caring for adults with intellectual disability. So maybe you'd like to share first?
Okay. So I mean, definitely, in terms of this particular scenario in which you have an elderly caregiver, so it's a reverse thing here, right? Yeah, just now we had a younger caregiver caring for the aged parent in that sense, which is something that is very common that we see. But definitely, this is also a very common scenario actually, and it is increasingly seen in today's setting because of increasing longevity as well of people with intellectual disability. Yes. Last time in the past, what used to happen was that when people with intellectual disability did not live for so long, many of their parents would actually outlive them in that sense. And then they would actually care for their adult child with intellectual disability till the day that their child actually dies. And then the parents, continue their lives, and then eventually they then pass on in their own lives. But now this is actually becoming an extremely, extremely common scenario. Yeah. And I think this is actually a very, it's a complex scenario in that sense, because here you have a mother who is aging, who has to plan for herself, right? Because she is aging, which means that she is also likely to develop health problems and other sorts of functional issues herself. Yeah. And what if she gets a stroke herself, 5 years down the road, right? And she needs to do not just her will planning, but she needs to do her lasting power of attorney planning. She needs to do all of those things. But at the same time, she has a dependent, her daughter, whom she has to care for as well. And currently, in a sense, she is her daughter's everything, right? Like she is actually, even if she is not a court-appointed deputy for her daughter, she is in essence the deputy for her daughter in that sense. Yeah. Why is it that we use the term deputy, right? She's the parent, isn't it? Isn't it just that she's like the guardian or whatever it is. I think, again, to understand the context is that we say somebody is the legal guardian in that sense when they are of a pediatric age. That means when they are in their childhood years, parents actually have the right to make decisions for their children, right? Until the time that they become a legal adult, But, and it is the same actually, in a sense, for even a person with intellectual disability. That actually past the adult age, the parents are actually no longer considered a legal guardian. And if they actually want to, let's say, do specific things, for their child, let's say they want to purchase the property for their child and things like that, they would then actually have to be actually a court-appointed deputy legally before they can actually do some of these things in their adult child's name. But if you look at this particular scenario, if you think about it, whether or not there's a deputyship, Belle is performing as the legal guardian, as the parent, as the deputy of her daughter Samantha. Okay, so by everything, right, that is exactly what is happening on the ground. Okay, and when I say this situation is complex, is because now she has to, as she plans, she has to plan for herself, she has to plan for her own death in that sense. Okay, and she also has to plan for her daughter while her daughter is alive. If she loses capacity while the daughter is still alive, that means if Belle loses capacity while the daughter is still alive, and she also has to plan for the daughter when Belle herself passes on. That means she has to plan for life of Samantha after Belle is no longer around. So there are actually multiple things that this particular family has to plan for. And that's why it is more complex actually compared to the previous case in that sense. I think without going into too much, the best way to think about it, I think, again, for everyone here is similar to what I said earlier in the previous scenario. When patients come to me, right, I always ask them, what is it that you want to plan for? What is it that is your final outcome that you're actually looking for? So same for this scenario as well. What I would always do with these families is that I would sit down and discuss with them, right, what would you like to plan for? Which part of life or whatever it is, right, are you most concerned about now? And then I would also ask them to envision, what do they imagine life for their daughter? What would be their best case scenario? Let's say I'll ask Belle, when you are no longer around one day, okay, what is your best case scenario for your daughter Samantha, assuming that she's going to live for another 20, 30 years? Tell me that scenario. And as she paints that scenario to me, then I would be able to look at the needs of Samantha. I would be able to look at the possibility of how Belle can support her in that sense, and then guide them in that planning. So that's how I would, first conceptualize this particular scenario.
And I think during our discussion, you mentioned something about, like, does this fall under advanced care planning or something that's not strictly legal? It's not really like, oh, you do a will because it only takes effect after you pass away, right? And LPA, not quite, right? Because let's say Samantha doesn't have the capacity already. And then deputy, so Belle is kind of like de facto functioning like the deputy for the daughter, is that what you're saying? Although maybe not really appointed by court to do so, right? But you're telling, in this scenario to think a bit further about their care planning, right?
The term that we use, right, and you will hear a lot about it, right, nowadays, is called future care planning. So we use this term future care planning a lot when we talk about people with intellectual disability and how their parents plan for them. Essentially is to plan, there are many terms that we use. Sometimes you hear people say it's planning for life after death. Life of the child after the death of the parent. Because you plan for them, right? Because while the parent is alive, the parent does everything for this child. And ensures that this child is as well taken care of as possible. And when the child is sick, they bring the child to the doctor. They speak up for the child. They fight with all the different professionals that they come across, including doctors like myself, about what is right and what should be done for the child. But the day that they are gone, their greatest fear is that nobody's going to do that for their child anymore. So that is, and we need to future-proof that in that sense. We need to help them plan when that happens. Then who's going to take on some of these roles? And the term that we use is future care planning. And when we talk about future care planning, we talk about everything. We talk about personal welfare, we talk about where they're going to live, we talk about their healthcare, we talk about their function, we talk about their recreational, what they do in their free time, we talk about finances, and all of those things. That comes actually under the entire umbrella of future care planning.
So it seems really much broader. It's not just merely legal instruments now, but really you're talking about all aspects of your life and planning for that. Maybe
I just add on another point. I think that an important thing to conceptualize all these things, right, is that legal instruments are instruments. They are not an endpoint in itself. You know, just like how just now we were saying, we will always ask the person, what is it that you're actually trying to do? And then perhaps let me help you conceptualize whether this actually needs to be done, or else maybe you can do it this other way. I think it's always the destination that we must look towards first. When we know the destination, then we can ask ourselves whether these particular tools, including legal instruments, are actually useful and necessary. If not, sometimes, right, all of these tools, right, can actually end up sometimes not helping them, and instead, making things worse for them. Or else, sometimes what it does is that it gives a false sense of assurance that you have done something by creating a legal tool. But perhaps you have chosen the wrong deputy. Perhaps you haven't made certain provisions in place, and things like that. So I will always say, look at the destination, and together with whoever it is that is supporting you, discuss and slowly figure out the steps that it takes to arrive at that destination, which may include legal instruments.
Okay, so perhaps this would tie into this question that's asked here. It says, may I know schizophrenia or bipolar or OCD, what legal documents can be drawn up by this patient? Is it a deputyship only? So again, going towards, what instrument must be drawn up with deputyship, but like what you just mentioned, maybe, is it even appropriate, or should we be talking about like maybe the advanced care planning part?
Okay, I think that first of all, right, the most important thing to understand is that a person who has bipolar, who has schizophrenia, or who has OCD, right, may have full mental capacity. Having these conditions doesn't mean that they don't have mental capacity. So again, capacity is different from the underlying health condition or medical condition that they have. There are many people with schizophrenia, many people with bipolar who have full mental capacity. And there is no reason why a deputyship even needs to be considered in that sense for them. But of course, we also have patients who have schizophrenia, who have severe mental health disorders, who may not have full mental capacity and may need some support in making decisions as well. But another very important thing is, like I said just now, if a person has got an underlying condition like this, then we must first make sure that they are well treated for their condition, and that they are in an optimal state before we even attempt to assess capacity. So I think that's what it is. And then another thing, maybe just to address what Mei Zhen said. So the term Mei Zhen used, right, advanced care planning, right, is actually a different term from future care planning. Future care planning is a different term. Future care planning is actually this umbrella term that we use to describe what it means to plan for the future of someone. It's actually, that's what it is, right? Planning for the future of this adult child when the parents are no longer able to care for her, because she has a life, that needs to be promoted, and that she should live well, regardless whether her parents are around or not. So that's future care planning. Advanced care planning is actually a term that we use when we want to discuss the options that people would like to have for themselves when they are nearing the end of life. So this is actually in the clinical and medical context that we do a lot of what we call advanced care planning.
So it's for yourself, that's advanced care planning.
It's for yourself, or it can also be for a family member. So I give you a simple example. One of the common things that we discuss in, let's say, an advanced care planning discussion is, for example, like now you're very well, right? Like, uncle and auntie, you're very well, okay? But what if you get a stroke tomorrow, let's say, okay? And then, if you get a stroke, then maybe you may have difficulty swallowing, right? And so then the doctor may tell you that you may need to have a tube, an NG tube, a feeding tube put in, for example. Or else you may suffer the risk of actually maybe choking on some of your food. Okay, how do you feel about this? For example, this is something that we commonly discuss. Let's say, I'm just giving you a simple example. And then the uncle and auntie, can say to me, wow, like that, I don't want the tube. Yeah, okay, yeah. Then we discuss with them, okay, why do you not want the tube? What is the reason for not wanting the tube? What if not having the tube means that you may get a lung infection and you may die from it? And we discuss these things along the way. Yeah, and then eventually we try and understand what is of value to that person. It comes out in this entire discussion. Yeah, what is of meaning, of value to this particular uncle and auntie as they live their lives, such that when a scenario like that actually happens, for example, we have an idea what is it that they would wish for themselves. Because if you imagine, at that point in time when it happens, right, uncle and auntie can't tell you, right, what they want for themselves anymore, right? Yeah, okay. So this is a different thing already, completely different. And it's more in the healthcare setting, this advanced care plan.
Okay, so what I gather is advanced care planning is what you would, certain more specific like medical treatment decisions you would like to do, whereas future care planning sounds more broad, right? Covers more aspects of your life, right? Okay, so yes, Peggy, I think you would like to share something? This scenario?
Yeah,
or just to the conversation.
Yeah, in respect of this scenario, right, I think we need to address Belle's concern. And Belle's concern is, look, I'm 60, I'm relatively young, but it is my daughter that I need to plan for her future care. So that's the future care planning that Shiling is talking about. So
her daughter's future care planning.
Yes, for Samantha's future care planning. So what can Belle as the mom do? She has already been caring for her for the past 30 years, right? But she's worried what will happen upon her death. So if she draws up a will, okay, let's say she draws up her, which she can, she has mental capacity, she can draw a will, and she can say, I'm going to leave, let's say I'm going to leave $100,000 to my cousin so and so that my cousin so and so can use this money to care for Samantha. I'm just using this as an example, okay? So she exhorts her cousin to use that money that has been bequeathed to her to look after Samantha. If the cousin does not do it and takes the money and goes on cruises and all that, right? What can Belle do? Nothing. What can the beneficiary, Samantha, do? Nothing, because Samantha does not have the capacity. So so I'm raising this to show that there's a lacuna there, and what Belle would need to do in order to ensure that the monies that she sets aside really goes towards Samantha's care. She has to ensure that she gets a professional trustee, or there is this organization called the Special Needs Trust Company, SNTC. It is a registered charity supported by the MSF, which guarantees the monies. So let's say Belle puts money in there. The minimum amount is $5,000 to put in there. And then what SNTC does, they have case officers for every single client to decide. And then this harks back to what Shiling has said, to decide, for example, where Samantha is used to staying. Let's say Samantha has been in a home and she does not like too many people, then her room should be only one, at the most share with one, or a single room. What are her likes, what are her dislikes? Because Belle is still alive and she's well, she is able to make these requests or inform the case officer about it. So and the money that comes for Samantha's care is actually held by the SNTC, Special Needs Trust Company, and disbursed by the SNTC specifically for the care of Samantha. And this money is guaranteed by the government, so that, other than a small fee that is being paid, very minimal fee for administration, all the money that Belle puts in there, which she can top up at any time, all right, all the money that goes in there will go towards Samantha's care. Okay, so that should give Belle some form of assurance, all right?
That if she were to set aside a sum, but she can't find any relatives to help her out, she can turn to this professional body, SNTC, right? But it's also a charity, right?
Yes, the Special Needs Trust Company. So you can find them on the website. They are very passionate in what they do, and it's very good work, because they actually fill up this gap.
But it would only be used for people like they will only help to disperse this money for people with like mental disability or intellectual disability, right? Like,
correct, who are not
right.
able to care for themselves, who have
Mm.
mental capacity to care for themselves.
Okay, okay.
But I think to add on to what Peggy says, right, the beauty of SNTC as well is that if Bell, in this particular scenario goes to them, right, they will also help Bell to plan. They will plan for Bell and Samantha. They would actually look at the amount of money that is actually that they are projected to need in order to live for both Bell and Samantha. They wouldn't just say, okay, look at what Bell has now, and then all of this is for Samantha. No, they would actually help Belle to project as well what she actually requires for herself. And of course, her fear that, let's say she loses capacity, right? But Samantha is still around and she can't care for Samantha. Actually, SNTC can plan in that way such that you have, in a way, two accounts, such that they can actually start to have plans and money that is used for Belle, even if Belle is still alive and has lost capacity, and then money that is used for Samantha at the same time in that sense. Yeah, because remember, Belle is, in a way, she's worried not just when she's no longer around, right? The truth is, she's also worried what if she loses capacity like tomorrow, right? Yeah, and she can't care, but it's the same idea. Yeah, so I think SNTC is very good at this and they can help to plan. So they do give assurance to families, at least that they can take care of the money part, and at least the money, like what Peggy says, is not going to be abused, because I think that's also the fear, right? Sometimes you're not sure what happens after that. Yeah.
Great. So I think we've covered all the bases that we wanted to for this scenario, hopefully. So yeah, okay. So perhaps now we could go on to our next slide and talk about how can caregivers protect themselves while discharging their duties, right? And after this, then we will definitely answer the remaining questions. Yeah, Q&A. So maybe Peggy, you would like to answer this?
I think caregivers have to, because we must distinguish between the caregivers that are listening today. We have caregivers who are family members, and we have caregivers who are caregivers, right? So if you have for both of these groups of caregivers, the commonality is that they are caring for a vulnerable person, right? So when we talk about protection for them, we look at it from the viewpoint that they might be exposing themselves to legal liability, right? So is there any instrument where they can say, I do this for you, but nobody can sue me? No. Can they have the aged person or the vulnerable person sign an indemnity? An indemnity is to say, I will hold you harmless, I will not sue you. No, because the vulnerable person cannot do that already, right? So to answer this, I would say there are practical steps. Like, for example, if a caregiver thinks, this person that I'm looking after is getting on in age, I will bring this person to a lawyer and I would be discharging I would be doing good planning. So remember what I said earlier, if you are bringing the person that you're looking after to a lawyer, ask yourself, if you are a caregiver who has other family members, do the rest of the family members know? If you are bringing if you're bringing, let's say, an aged parent, and you are the third child out of a family of 6, and the other 5 siblings do not know that you're doing this, and you're doing this on the quiet, it is setting yourself up, right? So if you say, but if I let the rest know, then it will be one big mess. Then do you want the mess now, or do you want the mess later, right? Of course, every situation depends, because yes, I've had several situations where I have warring siblings in front of me saying, no, my mother doesn't want this, no, my mother doesn't want that. But actually the mother is sitting in front of me and not daring to say anything. And this is when I send everybody away, determining that my client, who is the mother, has mental capacity. I send everyone away. And this is the one who then says and then tells me, you sure everyone has gone? And then she gives the instructions, and I get her to sign it, and it is kept at my office. And I advise her, no one needs to know what is in the will, because the testator does not need to tell anyone. But back to the caregivers, okay? So my advice is, if you are going to do things quietly without letting anyone know, then chances are there might be trouble later on. Right? So better to provide for that. Have a family meeting, especially when your parent is still around, and then have it all out and have it decided. Because that's when, if you say, oh, I'm the one who's been looking after mom, so I should be the one getting back reimbursement of all her surgery, all her surgical fees and all that, then have it all out and let them all discuss it, right? So better than to leave it later. Now that's for a will. For an LPA, because both for a will and an LPA, do you need statutorily, that means by law, do you need to get the consent of siblings? No, you don't need to go and ask, okay, Ahia, Ati and all that, can we do this? You don't need. But if you are applying to court for an order under the Mental Capacity Act, for that one, then all interested persons must know, which would be the siblings, and they would have to give consent. So you see, when I distinguish the different legal instruments, will only takes effect upon death, but if the person is alive, an LPA, if she has mental capacity, if no mental capacity, then an order under the Mental Capacity Act. So the court order under the Mental Capacity Act is really the most stringent, where you need to have the consent of the rest as well, right? But for the other two, you don't need, but as I said, to protect yourself as a caregiver, please, my advice would be have it all out. And if not, then you be prepared that there might be challenges. So what I will do to minimize this is I ensure that if the elderly Mrs. Tan is in front of me and she's drawing up her will, I will actually video, with her consent, of course, I will videotape her, and I will ask her questions. I will ask her not just the primary two questions, to determine that she knows what I'm talking about, but I will ask her questions about what she's doing, why she's doing that, what her rationale is. And sometimes I feel I've learned my clients appreciate this because it gives them a chance to be able to say what they want to say that they would not be able to say in front of the children. Quite sad in those situations, but it's a good way for them to express themselves. Okay.
I love what you said, Peggy. Do you want to mess now or you want to mess later? I need to use that next time in my consults. No, but I think
Go ahead.
No, but that's really true, I mean, that's such a good way to put it, actually, I think. Yeah, because if there is, if it's not in the open in that sense, right, you're right, the chances are there may be problems later on, which is also what we face in our clinical practice as well. Because then we get letters from lawyers after that,
Yes.
asking us to, write reports, or there may be something that's going to be contested in court and things like that. Yeah, and a lot of times it's because some things were not very clear, were not done in a very open manner. And sometimes, and it's very hard to say, right? Like exactly what you said, Peggy, sometimes it's to prevent problems that people do it like that because they know that it will be, or sometimes even the person themselves, the mother or the father may say, don't go and tell, just do, Yeah, but it's hard because if it's not clear, then later on there may be, competition, contest. And I think ultimately as a physician, because for my patients, I generally know the patient very well. I know the families as well, but the family members that we would know best are the ones that of course come with the patient most of the time. Yeah, for the consults. And the truth is, it actually is sad for us as well, when the families end up actually contesting and fighting over some of these things, because I always know that it is not the wish of the person, with dementia, for example, the elderly auntie or uncle, to have to watch this happen for their children. So I think better to, navigate this carefully.
Sometimes what I do when I see that my client is very troubled by this, I tell her, get the entire family together. Come to my office, and then I answer everyone's questions, because everyone has a different point of interest. It's where they're coming from, is their point of interest, not their view, is this their interest. All right. It is from their point of interest that their view comes about. So I will tell my client, I will tell the very troubled Mrs. Tan, bring everyone. Then when all the brothers, or when all the grown-up children are there, and most of the times with their spouses as well, okay, because the spouses also play a part even though they're not children. But then you know, everyone has a say, everyone asks their questions, it gets answered, and then I will ask Mrs. Tan, now what is it that you want to do? And so I become, you know, the facilitator for it as well. And then she gets to say, and it's all out in the open. So I find that when I do that, then I actually am able to help Mrs. Tan go over that hump, and then she can give instructions, and everyone is in the know.
No, that's
thereby
really,
avoiding the
great.
mess later.
And I think that takes actually hard to do that, right? To sit down and want to work it out with the family in that sense, which is you know, and for the benefit of the person who's coming to you as your client, which is, I think, really, really good. I think in the clinical context, I mean, we definitely don't do that for wills and LPAs, because it'd be very strange if the doctor says, come and sit down and we talk to you about will and LPA in that sense. But we do that for advanced care plan. Yeah, because you know those scenarios that I gave to you just now, right? Yeah, I think that's a great point, Peggy, because that's exactly what I do as well when there are conflictual ideas about what should be done and can be done when a person is nearing the end of life. And in fact, a lot of times I say to the children and to the auntie, you know, that it is precisely because all your children care about you. That's why they will all have viewpoints and opinions as to what is the right thing to do for you. Some will be more willing to let go, some may not be so willing to let go, some may have other thoughts and things and that. So it's best for everyone to come together, sit down, and exactly like what Peggy says, ask all the questions that they want from the clinical perspective. Yeah, you put in a tube, then what happens? You don't put in a tube, then what happens? If you do this, then what happens? And then we just answer every single thing. It can take 2 hours, 3 hours, don't know how many hours, 2 sessions, 3 sessions, but we just do it anyway. Because once it is done, then actually there is peace of mind. Yeah.
I guess on a related note, I'm not sure if you've already covered this just now, Peggy, but so when making an LPA, is it necessary to inform all the children?
No, that is not necessary. In fact, Mrs. Tan, the elderly, can draw up an LPA without naming any of her children as the donees. She can have outsider parties, you know, so the answer is no.
Okay. Then since we're on LPAs, guess here we can also just transit into the Q&A session, because there's still quite some unanswered questions. So this one, if after making an LPA with one donee and subsequently you want to add another donee, do you do another LPA or how do you go about it? And just a quick answer on the process.
Okay.
You have to add one more donee.
Yeah, you will have to sign a form, and essentially it is redoing it in that sense because the first one will already have been registered. So you want to add on one more, you have to do it again. There's another form to do it.
So it's essentially submitting a fresh one. So your earlier one would just be cancelled or terminated.
For the process questions, which
some are asking about doing it online.
Oh yes, in fact, doing online. Good reminder. And this news just came out with effect from the 14th of November. You can do your LPA online, but bear in mind, so doing it online makes it easier for parties to do the LPA. And as a lawyer, I would advise everyone, if you can, go and do an LPA because then you don't have to spend the money later on to go through the onerous process of applying to court for an order under the Mental Capacity Act. Okay, so please do an LPA while you can. Plus now, and I'm putting in a plug for the OPG's office. Plus now it is free. The registration fee of $75 is waived all the way until 31st of March 2023. So please do it now, because after that, from the 1st of April onwards next year, it will be charged. Okay, so what's not, go and do it.
Do it now. You can do it online. And so there's a question that says, do you have to submit hard copy with 2 witnesses' signatures? So I guess since you can do it online.
You know, even if you do it online, bear in mind that the LPA must be witnessed by, there must be a certificate issuer. And the certificate issuers are either doctors, but not any doctor, accredited doctors, or lawyers and psychiatrists. But of course, it is a whole lot cheaper to go to a doctor to do it. If you need to go to a psychiatrist, that means the patient is probably teetering on, on the edge as far as capacity is concerned. All right.
So you still need to do it, go to a certificate issuer to do it. Yeah.
Correct.
The process now online. Okay. So now I see that we have about 6 minutes left, and there's this question that has 7 votes. It's the most popular question, so I must address it. So it says, for childless people, it is hard to find appropriate donees for a lasting power of attorney, right? People around us might not be capable of handling personal welfare and financial matters. So what do you suggest for us to do? So perhaps I'll pitch this at, I would think maybe when I'm 50 or something like that, and if I don't have a child, you'll be thinking about these kind of scenarios. Yeah.
As I said earlier, your donee under an LPA does not need to be somebody related to you. That does not need to be your child, or it can be a cousin, or it can be any family member that you feel would be able to handle your affairs if you should lose capacity when you're alive. And if you can't, then go to the MSF website. There are professional donees that you can appoint. All right. So and they are regularized. They are regulated. There's a fee that's payable to them, but these are professional donees in the event that you can find one. So go to the MSF website. It is all there as to what the list is. You can find them there and choose which one you want.
And I think based on just some reading up, these professional donees or can be doctors or lawyers or accountants, nurses. Yeah. So if you don't have a relative or a next of kin, to be an appropriate donee, you can get a professional one. So we hope this answers your question. Okay, so so there are also like a bunch of questions about wills and what kind of assets can be covered under wills. Let me just quickly flesh out the questions, and maybe Peggy, you can answer them. Such as, CPF accounts, nomination, does it have to be covered under wills or not? Because you can just make a nomination. And as well as bank accounts, must they always go to the surviving joint account holder, or can you will the bank account with somebody else? And lastly, of course, like you mentioned, what if we don't do a will, but some people also, they're very well informed, they know that it will be administered quite slowly, is it true? So will it cost more money to administer it when you pass on without a will, although the asset is very straightforward? Yeah, so maybe Peggy should address them.
Okay, let me take the last question first. Again, it is a very common misconception. So I have clients often coming to me to say, if I don't draft a will, government will take my money, right? So putting the government. They do not take your money away. And then the other misconception they say is that, if I don't do a will, it will take a lot longer. And actually, there's only one additional document to be done, and it should not cost more. If it does cost more, then, okay, I'm going to say this at the risk of offending some people, but it should not cost more. Okay, it should not cost more, nor should it take considerably longer. So really, if there is no need to draw up a will, if my client comes to me to say everything that I have upon my death goes to my wife and to my 2 children in equal shares, but that's what would happen anyway by default in any event. So then I'll say, do for what? Don't do. No need to do. Okay. All right. So that's one situation. Your next, the other question is about CPF.
Yes, nomination.
Upon a person starting to work, the person would make a CPF nomination, because every month there's CPF monies being deducted being paid in by the employer, right? So there would be a CPF nomination. Bear in mind though that when this working person gets married, that nomination is invalid, and you need to make a fresh nomination. All right. So and after having done that, can you then provide for your CPF monies to say, I want it to go to my wife? Actually, if your nomination, even after marriage, you've changed it to your mother would be the one getting the benefit of those CPF monies. So the short answer is CPF balances, it will go and it will devolve according to the nomination and not by way of the will, right? And then
about bank accounts.
Yeah, bank accounts. So let's say Mrs. Tan has a joint bank account with her son Max, right? In your scenario, but there are many other siblings, and the other siblings tell Max, hey, this amount that you've got in there, because strictly speaking, Max can then say this is a joint account, so it's between me and my mom. Everything that I have, now that mom has passed away, I take it all, right? But if the other siblings can show that, look, the monies that went into this account came from them, came from their upkeep, their maintenance upkeep to mom, and the home and the ang pao monies that they've been giving to mom every time, and therefore they don't want, and therefore they're telling Max you cannot have it, then they can lay a claim to it, right? So what's a good thing for Mrs. Tan to do? She should then say very clearly in her will that in this joint account that I hold with Max, all right, only 30,000 belongs to Max. The rest of it is all my money, and this is how I want it to devolve. Because strictly speaking, under a joint, if the bank account is held jointly, it all goes to the other joint account holder.
Unless they say otherwise, like in the will.
Clearly, right? Clearly. But of course, there must be proof, because if Max then says, hey, my mother, Mrs. Tan, when she wrote that, she was being brainwashed by all her children, by the rest of the siblings. So that's when another war will start. So it really depends on the factual scenario. Okay.
Okay. Right. So I see that it's actually already 8:30, but we still have a few more questions that are not answered. So maybe I would just cover one last question, and then after that we can wrap up. I'm not sure if it's okay if we just go a little bit over.
Sure.
So, and this is something that we have not mentioned about yet. So this question goes, what if other children do not want to care for the elder parent and pay for their fair share, leaving it to just one child as the main caregiver and main contributor? So what can this sole caregiver do? So I guess the Maintenance of Parents Act comes to mind. Yeah, and the recent amendments as well. So yeah, Peggy, maybe you would like to share about that.
You're absolutely right. You've answered it already.
I was once. Okay,
but the application would have to be made. But the application would have to be made by the parent, not by the only child who has been caring for the parent. The application must be made by the parent.
Right. So that's the short answer. The parent needs to go and apply, and if the parent doesn't do so, then
well, if the parent does not want to do so, then legally speaking, there is nothing that let's say is the youngest son, and usually it's the younger ones, is the youngest son who has been the one maintaining the parent all this while. The youngest son cannot say, hey, after the parent passes away, I should be able to claim back everything and all. So this is what I mean, if it can be done, then have an all-out pan pie, everything out open, and then say it out first.
In fact, I think there may be some legislative amendments coming up soon where the court can do so on their own, even if no parent applies for it. But okay, so I'm so sorry we didn't get to answer some of your questions, but we're 2 minutes over and we have to kind of wrap up now. So we have to bring this to a close. So at the end of this webinar, a survey form will pop up on your screen for you to complete. We appreciate your comments as they will be used to improve future webinars. And there are many more webinars as part of the Law Awareness Weeks at CDC 2022. So please scan the QR code or visit the website bit.ly/lawcdc2022 to find out more about other webinars as well. Then if you face any legal queries and you're keen to register for a legal clinic session, you may email inquiry@law.probono.org. So I would really like to express my deepest appreciation and thanks to Peggy and Shiling for sharing your knowledge and experiences with us. And with that, we would like to thank all of you for joining us today and have a good week ahead. Yeah, as for the questions we didn't get to answer, I'm not sure, maybe you can check with the organizer later. Can we somehow get this to you? Yeah, but I hope every one of you has benefited from it. And yeah, see you. Bye.
Bye.
Thank you. Bye.
Thank you.
Mm.